welcome everybody. Thank you for joining us tonight for a discussion on reproductive rights and what's at stake. We're very happy to have two preeminent experts on the topic, and of course it couldn't be more relevant right now. Unfortunately, yesterday Amy Coney Barrett was confirmed to the Supreme Court, and so this is a very timely conversation, but we of course, while many of us are disappointed, remember that we might have lost a battle, but we're going to win the longer war. And that's what we're going to be talking about today, is how all of you can take action. So my name is Sarah Levin. A lot of you might recognize me. I'm the program coordinator for Jews for Secular Democracy, which is a pluralistic initiative that is mobilizing and galvanizing the Jewish community to protect the separation of church and state. And so we have two experts here today. We have Shannon Russell and Scott Ruskay-Kidd. Shannon is the National Council of Jewish Women's Legislative Council. She leads federal advocacy efforts surrounding the priority issues of reproductive health, rights, and justice. In her capacity, she meets with members of Congress, their staff, and administration officials to discuss pending legislation and regulations. She creates written materials like talking points and action alerts, and manages relationships with coalition partners and NCJW advocates across the country. Her portfolio also includes healthcare and religious freedom issues, and she graduated from George Mason University School of Law with a JD in May 2018. So she is very well positioned to give us our action items and marching orders today, and to explain what we should be expecting. Scott serves as Senior Staff Attorney for Judicial Strategy with the Center for Reproductive Rights, a 170-person legal organization that advances women's reproductive rights worldwide. For 25 years, the center has been the driving force in many of the most significant legal victories, ensuring access to reproductive health care. So we're excited to hear from him, kind of what we can expect. Unfortunately, it feels like we've taken some steps back, so we're going to take some time to understand sort of where we're at now. The center's game-changing litigation and unparalleled expertise in constitutional, international, and comparative human rights law have transformed how reproductive rights are understood by the courts, governments, and human rights bodies. He's working on developing new legal theories, managing strategic alliances, and strengthening the jurisprudence protecting reproductive rights. And he graduated from Harvard University, magna cum laude, very impressive, and Columbia Law School, and clerked for Judge Robert Patterson Jr. of the Southern District of New York and Judge Robert Sack of the Second Circuit Court of Appeals. So no shortage of expertise here. But before we start, and I am going to be switching back and forth with Lincoln, our community organizer, asking Shannon and Scott questions. And then at the end, we're going to be taking your questions. So please do use the chat or the Q&A to submit your questions. We'll be looking out for that. But before we get started, we wanted to take a moment to recognize the second anniversary of the attack on Tree of Life Synagogue and to read the names of those lost. And Shannon will be leading us in that.
Sure. So yeah, we just want to take a moment to recognize this moment and to honor those whose lives were lost. Those include Joyce Feinberg, Richard Gottfried, Rose Mallinger, Jerry Rabinowitz, Cecil Rosenthal, David Rosenthal, Bernice Simon, Sylvan Simon, David Stein, Melvin Wax, and Irving Younger. May their memories be for a blessing.
Thank you. All right, so the first question is, I'll turn it over to Lincoln. It's for you, Shannon.
Thank you, Sarah. Thank you, everybody, for being here, in particular, Shannon and Scott. Shannon, the first thing I wanted to ask you about has to do with the intersection between religious freedom, reproductive rights, and the separation of church and state. As Sarah mentioned, this initiative is focused on galvanizing the Jewish community to defend the constitutional separation of religion and government. And I think one of the implications of having religious interference into government is infringement upon reproductive rights. I was hoping you could tell us a little bit about that history and how the two issues are intertwined.
Yeah, I'm so glad we're starting here because this is such an important issue and it is the core of NCJW's work. So at NCJW, we work to highlight how restrictions on abortion access intersect with other issues like economic justice and voter suppression, immigration, the courts, judicial nominations, and as you said, religious freedom. So as we see it, reproductive rights and religious freedom are integrally bound. So one cannot exist without the other. And here's why. Pregnant people are moral agents who have the capacity, right, and responsibility to make their own decisions about their sexuality, reproduction, and their families without political interference. But legislation that eliminates health coverage for or limits the availability of abortion severely constrains patients' ability to make decisions about their own healthcare and about how best to care for their families, guided by their own consciences and personal circumstances, and for their families. And what's more, policies restricting access to abortion conflict with Jewish tradition by jeopardizing the life and health of pregnant people, which is always considered paramount. And it interferes with providers' ability to offer care that is affirmatively motivated by their faith or their moral tradition. So Jewish historical experience, including in the US, calls on us to honor religious liberty. And we see that as both freedom of and freedom from religion. So we understand that some of those who would restrict access to abortion and reproductive health care cite their religious beliefs as their motivation, and that they seek to force these beliefs on other people. However, our US Constitution and our beliefs demand that no one can impose a single religious view on everybody, and this is the foundation of our democracy.
Thank you for that. The next question is for Scott, and we actually just got a question in the Q&A that kind of really is a great primer for it. Arlene asked, do we need a new strategy to support reproductive rights? Can we no longer depend on the courts to protect our rights? Thank you, Arlene, because the next question was, that there's a lot of concern that now that Amy Coney Barrett has confirmed that the court will overturn Roe v. Wade. So Scott, how likely is that to happen? What are the best and worst case scenarios we should expect to come out of the court regarding reproductive rights decisions kind of more generally, even beyond abortion?
Well, the first thing, there's sort of two questions there. One is a bigger concern, what happens when we rely on the courts and can we continue to do so? And the other is what's with the future of Roe versus Wade, particularly with the new composition of the Supreme Court. As to the first sort of broader question, the first thing that sprang to mind is a quotation by a judge many years ago, and I'm going to botch it, but it's about this, because I don't have it memorized, but it's about the spirit of liberty, and this judge made the point that the spirit of liberty cannot be guaranteed by our laws, by our courts, if it doesn't live in our hearts, in the hearts of the people. And I think that feels especially true today. It is ultimately in the people that and their votes and their voices and their efforts and their spirit that liberty is guaranteed. Courts will shift. Sometimes it will seem like the processes for nominating judges or justices to the Supreme Court become very partisan. Sometimes politicians make a big deal out of filling the courts with judges that they think will rule their way. At the same time, there is, I think, an abiding spirit of our Constitution, which does continue to give me some measure of confidence and strength that the courts will continue to do what is right. That's what we expect them to do. At the same time, we prepare for all eventualities. Roe versus Wade, I don't know if it has ever been secure. During the 1980s or 1990s, 2000s, it has been under relentless attack. And and a lot of that has happened outside of the public eye. Since in the last decade or so, there's been more than 400 restrictions quietly passed by politicians at the state level. There are many states that have, one clinic left. Access is a tremendous issue, and the right exists in reality in New York, where I live, and if you live in certain states, Louisiana, some other certain states, it can feel pretty hollowed out already. So it's not like things were really great, even last year or 10 years ago. They were not what we would hope that they would be. That people to facilitate people making choices and effectuating choices about their families and their destinies. I think there is a lot of talk about Roe versus Wade being on the line, and Judge Barrett, now Justice Barrett, has been confirmed to the Supreme Court. Her prior writings indicated strong opposition to the constitutional right to abortion, and also included strong advocacy against related to contraception, a belief that life begins at fertilization is one that she had signed on to. At the same time, during her confirmation hearing, she said she would not let her personal views influence her rulings, and we hope and expect that to be the case. In the best case scenario, the court recognizes the importance of the rule of law, the importance of liberty and equality, and precedent. And in the worst case scenario, we are having to look outside of the federal courts to wage a ground battle in state legislatures, in state courts, perhaps in the federal Congress. There is a tremendous amount at stake, and I live with one foot in sort of the fighting the fight and having the confidence in our efforts, and the other foot with real fear for what turning the clock backwards 50 years could really mean for people's lives, because that is ultimately what this is, what so much of the law is about. It's not abstract doctrines, it's what does it mean for a woman, for a family, for a person who becomes pregnant, when they don't get to make the choices consistent with their own conscience about how to structure their lives.
You went through the best case scenario, but just so we can brace ourselves, what is the worst case scenario?
The worst case scenario is the Supreme Court overrules Roe versus Wade, says there is no constitutional right to abortion, and very quickly abortion would be banned in a large number of states. There are states that have on their books trigger laws, which say if the Supreme Court, essentially say if the Supreme Court were ever to overrule Roe versus Wade, then immediately it would become illegal in our state. There is I believe it's in Louisiana, there is such a trigger ban, sort of an amendment to their constitution that is on the ballot in November here. So you would immediately see abortion become illegal in many states. You would also see abortion become severely restricted in another number of states, and you would have a situation where people with means could travel to New York, perhaps, and people who are not facing a lot of structural barriers, low-income people, people of color, people with disabilities, people facing overlapping barriers, without the resources to travel somewhere else might find themselves in living in a state that requires forced pregnancy.
And I imagine that's not something that the Supreme Court would just take on. There would have to be some preceding event. What can we expect, essentially, our opposition to do? What kind of case would they bring forth to kind of trigger that? Is that something you could just briefly?
Yes, there are so many cases because politicians are very active in using this as a wedge issue, and I think in 2019, we really saw an uptick in bans from 6 weeks after conception. That's probably 2 weeks after you missed your period, and a lot of people don't know they're pregnant at that point. And there are various states that have passed bans at various sort of stages earlier in pregnancy, and those are all flatly unconstitutional under current law. And the politicians passing those bans are quite explicit that we want this ban to be litigated, and the Center for Reproductive Rights and others bring cases and get those struck down. But the politicians say we want this ban to be taken up by the Supreme Court. There is currently, I think, a request by Mississippi, if I remember correctly, asking the Supreme Court to weigh in on one of those cases. There are also cases that would investigate the reasons why a person has an abortion. Under current law, that's the definition of choice. In Roe versus Wade and its major sort of reaffirmation in Planned Parenthood versus Casey, the Supreme Court said, look, our job is to figure out what constitutional law should be when people disagree. The court said men and women of good conscience will always disagree on this subject, and its spiritual consequences, if that's your background, of its implications from a point of view of conscience and life decision making for everybody, that the government, the ultimate decision is the woman's, not the government's. But there are some cases asking the Supreme Court to crack open the door and say some reasons, even from the very beginning of pregnancy, some reasons are good and some are bad. There are some cases that are in the pipeline that would outlaw the principle and the safe standard method for second trimester abortion. Ballpark 90% of abortions happen in the first trimester, and it's a relatively smaller number, and often very difficult circumstances when one is looking at a second trimester abortion. There are all sorts of reasons and stories for those situations, but there are some states that have tried to ban the method used for those abortions, and those have been struck down by numerous courts under current law. But politicians will be trying to get the Supreme Court to hear those types of cases as well.
So it sounds like from what you're saying, there's a few cases that are just ready to go. Yes. I mean, how quickly could we see that timeline? Within the next few months, next summer?
Yes, within the next few months. It's so much is in the Supreme Court's discretion as to when it takes cases. The court's calendar is its own to make, but there are cases that will give the court the opportunity to do what it wishes at any point.
Good to know, to prepare.
It's urgent. It will always be urgent. And if 6 months go by and the court is quiet, in month 7, it could announce it's hearing a case.
So I have one more question for you, and then we're going to go back to Shannon. So we're a nonpartisan organization, but it is clear that Joe Biden and Kamala Harris's platform is more supportive of reproductive rights than Donald Trump's. So if Joe Biden wins this election, what options will his administration have to protect these rights, and what options will Congress have? I know you mentioned state legislatures, and we did have a question here asking, what we can do to encourage legislation to improve reproductive rights instead of relying on the Supreme Court. But I want to narrow in and sort of what are the options in the hypothetical case that we have a Joe Biden administration and say, the Democrats, who again, we're nonpartisan, but I think objectively it's pretty clear that the Democratic Party tends to favor expansion of reproductive rights rather than limiting. So anything you can give us in terms of what our options are in that hypothetical.
Sure. So the Center for Reproductive Rights is also a 501c3 nonpartisan organization. So, I'm not here to comment on any particular election or vote, but I can speak to there's a federal statute which I think has been mentioned in some of the presidential debates that had a hearing I want to say it was last February, earlier this year, called the Women's Health Protection Act, which would essentially codify Roe versus Wade. It would be Congress using its power to enforce the 14th Amendment's protection for liberty, and also its power to regulate interstate commerce, to protect access to abortion, to forbid state-level bans. There's also another act, sort of proposed statute that is called the Each Woman Act, which would provide for funding of abortion care for people who are indigent and otherwise are going to be looking at forced pregnancy. So there's various things that can be done at the statutory level. Also, a lot happens at the regulatory level. And this is where it gets really boring or dense. So I'm going to make it really short. But there is a lot that happens at the regulatory level that the public doesn't necessarily see, but that impacts people's lives. It can impact whether an undocumented minor is held in a cage at a young age. It can impact whether an undocumented minor can obtain reproductive health care. It can impact whether hospitals and other healthcare providers can refuse to provide medical care or medical information based on their own personal religious or moral objections to the life choices of their patients, whether that be a woman seeking reproductive health care or an LGBTQ person, or somebody asking for a vaccine with pork ingredients, or that had some other thing that was objectionable. There's a lot that happens at the regulatory level, and a federal administration would have a lot of choices to make to support those small but not small, often unseen but often very impactful ways that the government touches our lives.
Thank you. Before I turn it over to Lincoln, I want to, because I know, Shannon, you're going to be talking about the legislation in greater detail later for attendees. And one thing, as you were explaining, Scott, one of the things that I think you said that the Women's Health Protection Act does, and I'm curious, Shannon, if you can speak to this. If it's going to ban state bans, couldn't that also then be litigated and be brought to the Supreme Court? So I'm curious if you could address that, and then Lincoln has your next question.
Yeah, I mean, any accomplishments that we make in terms of this can be litigated in the courts, and yeah, but I think that WIPA, or the Women's Health Protection Act, is a really great piece of legislation, and it gives providers an affirmative statutory right to be providing care free from all these restrictions that we have seen that Scott talked about. So of course, there's a chance that, like anything that could happen, that they could say this violates the Constitution and bring a case about the Women's Health Protection Act. So yeah, getting it passed is one step, and then keeping it law is the next step.
Perfect, thank you. The next question I had for you, Shannon, and kind of a segue into this, looking at the recent Supreme Court confirmation hearing, which we didn't see much of because of how rushed it was, but one of the messages that did come out from Senate Republicans that they really tried to make stick was that critiques of Justice Barrett's jurisprudence and views on pro-choice related cases were attacks on her faith, attacks on her Catholicism, which is, of course, completely unfounded, but it raises an interesting question, which is that how do views on abortion differ between different sects of Christianity and Judaism? Of course, we are a pluralistic Jewish initiative, and how should government go about accommodating those different views in public policy?
Yeah, so of course, their views on abortion vary widely among and within denominations of Christianity. So I'll start there. So while it's well known that the institutional Catholic Church currently opposes abortion from the moment of conception, there was actually a long period of disagreement in the church over the status of the fetus. And there's still a massive disconnect between the views of Catholics, everyday Catholics, and that of their clergy and their scholars. So 98% of sexually active Catholic women have used a form of contraception, and a majority of Catholics view abortion as a moral choice. And Catholic women today have abortions at approximately the same rate as non-Catholic women. And Protestant denominations generally recognize that pregnant people are moral agents, like I said, who have the capacity and the right to determine whether an abortion is justified in their specific circumstances, and that this decision should be made under the guidance of spiritual counselors. And this is generally the strong consensus among Reform, Reconstructionist, and conservative rabbis. Jewish sources firmly position abortion as healthcare, which is a decision to be made in consultation with one's provider and family. Judaism values life and affirms that protecting the existing life of the pregnant person is paramount at all stages of pregnancy. So various Jewish sources explicitly state that abortion is not only permitted, but is required should the pregnancy endanger the life or the health, meaning both psychological and physical health of the pregnant person. And so a fetus is not considered a person under Jewish law, and as such, it doesn't have the same rights as one who's already living and functioning in the world. So this is why NCJW has written and spoken extensively on abortion as a First Amendment religious freedom right. So policies that grant fetal personhood rights or establish that life begins at conception are contrary to these Jewish teachings that I just talked about, and they violate the First Amendment's Establishment Clause by enshrining one religious view of life into law. And this is really an overarching theme in many of the harmful policies that have been designed and implemented by and during the Trump administration. So as Scott just said, a lot of this gets done through regulation, and there is an intentional push on the part of the government right now to make policy and to interpret the law based on this narrow understanding of conservative evangelical Christianity. So from day one, the Trump administration has really turned this concept of religious liberty on its head and launched a sustained and coordinated attack on women, low-income people, people of color, people with disabilities, young people, immigrants, and LGBTQ individuals. Specifically, our nation's founding principle of religious liberty has been manipulated in attempts to decimate the Affordable Care Act's contraceptive benefit, to eliminate critical protections against discrimination in healthcare for transgender patients and for those who have had an abortion, and to authorize refusals of care based on religious or moral beliefs of healthcare and entities. So this is just an example of what Scott was talking about. So Trump's refusals of care rule is particularly egregious because it vastly expanded these existing regulations to allow any individual or entity involved in a patient's care to refuse to provide any part of a health service or program. So this means that a hospital's board of directors or an insurance company or an individual provider or even someone who schedules procedures can refuse to provide an abortion for, say, a pregnant person who's in an acute medical crisis, or they can refuse to stand by patient preferences for transition-related care. And for many of these patients, these refusals of care aren't simply a temporary inconvenience. It's not like they can just find another doctor, but they actually result in the delay or the outright denial of vital care. And this is particularly dangerous in situations where individuals have limited options, such as in emergencies or folks who live in rural areas or in areas where religiously affiliated hospitals are the primary or sole institution serving a community. So we call this rule the unconscionable conscience rule, because it's simply despicable to threaten patient lives, health, and moral autonomy by refusing care. Refusals clauses and these regulations also compromise the religious liberty and ethical obligations of healthcare providers, as I said before, and interfere with their ability to provide care according to not only their professional standards, but to their care that is affirmatively motivated by their moral beliefs. So we know that true religious liberty signifies both freedom of and freedom from being forced to live by another's beliefs. And so the proper role of government, right, is to ensure that freedom of conscience is and fair treatment for all, and not to use religious freedom as a political tool. So the administration threatens the religious liberty of all people when it enacts policy to align with one interpretation of one religion, and when it allows employers and healthcare providers, business owners, and government officials to use their individual beliefs to thwart our nation's civil rights laws. So to this end, NCJW actually supports the Do No Harm Act, which is a bill that would amend the Religious Freedom Restoration Act, or RFRA, which is used to justify many of these policies. And the Do No Harm Act would clarify that RFRA can't be used to harm others. And you can learn more about this bill and the blatant misuse of RFRA at protectthineighbor.org. And this is a really important bill too.
Awesome, thank you. So the next question is for Scott, and I'm gonna roll in also a question we got in the Q&A because someone asked about the morning after pill and whether that could be banned. And, the question is, obviously abortion is the issue that tends to grab headlines, and it's on all of our minds, especially with Justice Barrett's confirmation. But we know that the full range of reproductive health care is at stake, and Shannon just talked about that as well. So contraception access, maternal health, assisted reproduction, and more. So can you speak to the policy and political landscape that we're facing on those issues?
Gosh, so I used to do business litigation, and I did work for the Center for Reproductive Rights on a pro bono basis. And when the 2016 election happened, I saw there might be a real need, and came to do that work full time. I grew up in Canada, and my sister, when I told her I was going to go work at the Center for Reproductive Rights full time, she said, "Abortion's still controversial in the U.S. I don't get it. Doesn't the pregnant person just make the decision?" So she had befuddlement that was still controversial, and I come to 2020 with amazement that contraception is controversial again. We are fighting battles that we never thought we would have to fight. The Trump administration passed regulations that roll back access to contraception, that really, in defiance of science, reversed the Obama administration, probably prior administrations' views that contraception is effective at reducing unintended pregnancy rates. The very efficacy of contraception all of a sudden, went from a real sort of minority view that you would see in some strongly religious organizations to the heart of government. And the morning after pill, even IVF, forms of assisted reproduction could be controversial. For example, now Justice Barrett had made a number of statements and signed on to a number of statements about these sorts of issues in the past. One of them, as I mentioned earlier, that she signed on to did refer to life beginning at fertilization, which would imply that IVF, which involves multiple embryos, and certainly something like the morning after pill, that would be controversial. And there's also, as Shannon has alluded to, a real issue with the offensive. I don't mean that in a sort of an off-putting way, but in the as a sword instead of a shield, and with the offensive use of religious liberty to refuse and deny access to health care to people. So issues like going to your pharmacist and not being given what your doctor prescribed for you are really at issue these days. And it continues to befuddle me that there's not just a sort of a recognition that the contraception access, healthy pregnancy, healthy delivery, abortion, if that's appropriate, assisted reproduction, if that's useful, bearing your kids in a health and safety manner, raising them in a healthy and safe manner, it's all the same fabric of life. It's not that there are, I believe it's about 1 in 4 women during their lifetimes who will have an abortion, and that not everybody knows that. It's not talked about by everybody. People don't always talk about their miscarriages. There's privacy sort of interests around this, as Roe versus Wade recognized, among other things. I believe it's about 60% of people who have abortions are already parents. This is part of all of these things are aspects of human life, of reproductive life. And the similar sort of objections and themes run through opposition to contraception, to abortion, to the full range of reproductive health care. And really, I think sadly, there's sort of a misnomer of sorts when the label pro-life is used, because there's much less care for women and children, in birth, after birth, at the same time as the rates of maternal mortality and morbidity, health problems short of death, has been going down worldwide. In the US, it's been going up. And for Black women, it is, I believe it's about 3 times as high as for white women. There's a pervasive theme that our country is not really doing right across a whole range of reproductive health care.
Thank you for that. With all of that kind of depressing but important insights. The last question is really geared toward action, because a lot of us are feeling a lot of despair and and wanting to do something about all of this. I'll let Lincoln ask that last question. Then we have a number of questions to get into from attendees.
Yeah, thanks, Sarah. And this question is more directed at you, Shannon, but would certainly appreciate any guidance. And that is just how can our community, the Jewish community, and particularly our Jews for Secular Democracy volunteers who are watching this presentation with us live and recorded in the future, take action? What can we do now in the face of what feels like escalating challenges and very little time that we have to act? What can we do today to try and protect these important rights?
Yeah, so I'm just about to drop a whole bunch of links in the chat. You can immediately take action. So both of these proactive federal bills that we just talked about, NCJW and other partners like Catholics for Choice and the Religious Coalition for Reproductive Choice have put together these petitions for both of these bills. And they are for people of faith and conscience to call on Congress to pass the Women's Health Protection Act, which, like we said, would get rid of all of these ridiculous state laws that we've seen. So laws that even force clinics to make their hallways a certain width or have certain lighting in the clinics, or force providers to tell their patients that they are going to be at an increased risk of breast cancer if they have an abortion, which is totally not scientifically true at all. So WIPA would get rid of all of these laws. And then the other bill that we're talking about, the Each Woman Act, is equally as important because it would get rid of the Hyde Amendment, which is a blatantly racist policy that was designed to deny care to people on Medicaid. And it has expanded since then. So it now applies to all of these different federal health programs. So think the Indian Health Service, or even Peace Corps volunteers, survivors of human trafficking. There's even a ban that prevents DC from using its own money to fund abortion through DC's own Medicaid program. So we really say that these bills are two bills, one movement, right? So WIPA makes sure that everybody can access care because it gets rid of all of these ridiculous laws. And then the Each Woman Act ensures affordability of this care, because you can't, abortion isn't accessible if you can't afford it, right? So these two bills really go hand in hand. And those are the top two links. We also have action alerts for both of these bills, so you can send an email to your senators and to your representative, encouraging them to either call for a vote on these bills or to support them, become a co-sponsor, and you can customize the emails that you send to lawmakers. And we have one for the Each Woman Act, one for WIPA, and one for both, because like I said, they really work hand in hand. And the final take action item I have on this list is our new Courts Matter website. So NCJW is also a 501c3 nonpartisan organization, but we do take positions on judicial nominees and executive nominees. So as we know, the courts impact every single issue we care about, including reproductive freedom. And there's two nominees right now who are anti-reproductive freedom, who are moving through the confirmation process for the lower federal courts. So you can go to our Courts Matter website and take action to oppose those nominations as well. So it's really important. You know, the Supreme Court gets a lot of play because it is the nation's highest court, but our lower courts here, I want to say like 99% of cases, and they provide the last word on those cases. So lower court nominees are also really important as well. And then there's also things that you can do in your local communities. So as Scott mentioned, there's a ballot initiative in Louisiana right now. There's also a really bad one in Colorado, which would ban abortion at 22 weeks. And so there's a lot of groups working on the ground with those, get connected with folks that are working there. And there are also a lot of abortion funds. So for those who can't afford their abortions, or they can't afford to travel there, or any of the related costs, abortion funds can come in and provide that necessary money for them to actually access care. So you can look up your local abortion fund, see if they need volunteers.
Scott, do you want to add anything before we get into attendee questions on calls to action?
Shannon did such a good job covering it. I know our time is short, and there are lots of good links there. So, so many of the things she said, I also would have said.
Okay, great. Well, then let's move into these questions. So, someone asked if the Equal Rights Amendment can save Roe. So, if one of you can, or both of you can comment on how we should understand the Equal Rights Amendment as it impacts or doesn't for Roe.
Well, I can start off. I know that there is some amount of debate about that. I think that those who are working on the Equal Rights Amendment and those who work in reproductive freedom spaces aren't necessarily the same people. And so there's sometimes a little bit of a communication disconnect. And sometimes it's easier for folks to talk about the Equal Rights Amendment when they're not bringing abortion and reproductive freedom into the mix, because like we've said, it's such a controversial issue that they tend to focus on other things that the ERA could do rather than protect abortion rights and access. So I think that were we to actually get an ERA, which would be amazing, it's a matter of debate how far it would apply to reproductive rights.
I think that it's something that would end up being debated. You know, the Equal Rights Amendment is something which is, in some ways, a little bit. It's a little bit of a strange thing, because the United States stands out from some other countries, like Canada, my home country. I'm a dual citizen now. I'm married a New Yorker, but. You know, it's our Constitution is very old, and therefore it doesn't have language in there explicitly referring to women's equality, and that is stark and odd and disturbing. And yet, part of what has happened in U.S. law is, with real credit to the late Justice Ginsburg, starting in the 1970s, the Supreme Court really started to interpret the admittedly terse, brief language in the Constitution about equality and also about liberty, not just you know, according to the originalist intentions of the property men who wrote those words, but by asking the question, what do those promises mean to women? What should they always have meant to women? And so what Ruth Bader Ginsburg and others, you know, gave to us is a pretty robust constitutional jurisprudence that recognizes equality already. So it's a little bit hard to predict, and a lot could depend on the composition of a court. You know, would a judge view the existing constitutional law on women's equality as equal to, as different from the text of an ERA? It's not. I can't predict for sure what any given justice of the Supreme Court would do with that question. But look, it is undoubtedly true. You know, putting aside that sort of riddle, that reproductive rights are profoundly about, among other things, equality. The Supreme Court, in repeatedly reaffirming the right to end a pregnancy, has explicitly said that the ability of women to participate equally in the economic and social life of the nation is facilitated by their ability to control their reproductive lives. And there is a treasure trove of social science data, you know, backing this up, that poverty, exposure to intimate partner violence, mental health, physical health, all are impacted, and really the ability to be an equal citizen, and to have full citizenship. And I use that not in sort of an anti-immigrant sense, but in sort of an old-fashioned, you know, what does it mean to be a member of our our national community of we the people in a really inclusive and full way. That reproductive health care is very much about that.
Thank you. Great answers. Here's a question from Sheila and Ron. This is interesting. They said, if women's reproductive rights issues are not just about religion, but also about gender discrimination, would more women in positions of authority change anything? What do we think?
And do you want to go first?
Well, I always feel that it's valuable for folks in position of power to, have that lived experience of what it's like to possibly, be denied access to birth control because their employer says they can't have it, or be denied an abortion because they have to go through all these crazy loops, like waiting 72 hours and having an unnecessary ultrasound and all of these things. So I'm all for more women in positions of power, of course. And I think that, like I said, that lived experience is really important, and that, more of an understanding of how these issues are actually impacting folks on the ground, I think would be really valuable.
I think diversity and inclusion in all sorts of institutions is not just the right thing. It has been proven by people who study it to lead to better decision making, to more effective actions. This is true in corporate environments. It's true on a court, that if you bring together people from one background, or if you bring together people from different backgrounds, you will see statistically inferior decisions being made by the less diverse groups. We should have, in my ideal world, a Congress, a Supreme Court, with 50% women and 50% men.
Thank you. So David asked about states' plans to try to persuade pregnant women to give birth by offering resources to remove excuses. I think what he's probably referencing is crisis pregnancy centers. And I do, if I remember correctly, there was that case in California where they tried to crack down on crisis pregnancy centers and that did not go well. So is anything you want to speak to in terms of how can we deal with crisis pregnancy centers and that sort of forced disinformation at the state level?
Yeah, crisis pregnancy centers or fake pregnancy centers, fake clinics are a huge problem. And actually our New York section is super involved in trying to, stop that spread of disinformation and to really, like you said, crack down on these fake clinics. I'll also drop another link in the chat, but if you go to protruthy.org, you can see like this map of all these clinics in New York, and you can see like which ones are fake clinics, so just having that type of resource. And that's a program that we're trying to, the Pro-Truth program is something that we're trying to expand to other places in the US where folks might need it. And it also has like resources like what are fake clinics and how can you separate them out from the ones who are actually offering quality comprehensive reproductive health care. And there's also a federal bill that would stop, the misrepresentation of these clinics as if they are real abortion clinics, or that they offer really any form of reproductive health care, because most of them don't.
It is the fake clinics, I think is a good phrase Shannon used for them. There's there's really an effort to put on the appearance of a medical interaction while not providing health care, and there's a lot of deception and a lot of harm, and there can also be a lot of frustration of people's life choices because it's taking care of oneself and making decisions when pregnant. It's time sensitive, and if you're stalled or waylaid by a misleading sort of clinic, it can really set you back. The you know, the other sad fact is that you know, there are a number of states where the number of fake clinics is very large compared to the number of actual clinics where you could effectuate all of your choices around pregnancy. You know, we had a Supreme Court case that was decided this past June called June Medical Services versus Russo, where Louisiana, while not banning Roe versus Wade, was on the verge of, you know, taking its, you know, putting in, you know, sort of clinic closure regulations that would bring the state down to one doctor in one clinic for the entire state. So the contrast between the proliferation and sometimes state support for these so-called crisis pregnancy centers or fake clinics and for actual comprehensive reproductive health care clinics is a real problem.
I think we have time for one last question, and I'll let Lincoln choose because I need to plug in my computer, the joys of Zoom. But I did want to ask, because somebody asked about what Justice Barrett wrote about contraception, and I didn't want to, you know, that's something we can Google, but I wanted to ask if you happen to, either of you have, I don't know if NCJW or the center has like a comprehensive guide or of all the things that Justice Barrett has written. If there's anything like that, it'd be great if you could throw that in the chat. Lincoln, do you want to close us out with one more question?
Sure, I'll just bring up one more, and it's inspired by a couple of questions that we've had related to contraception, which is already something that we've talked a fair amount about in terms of the risks to access to contraception. But the way that I want to put it to either of y'all is that when it comes to talking to our peers, talking to folks who are concerned about the potential risks, but maybe don't know them so much. A lot of people are familiar with the risks to abortion, but do you find it to be less so that people know of the risks to access to contraception? And how can we go about educating people on those issues to ensure that we're all on the same page about what the risks are and what we need to do in terms of taking action?
I think that people take for granted that battles we fought in the past are, if we've won them, they're one and done. You know, it was only, I want to say, in 2014 that the Supreme Court first, in a case involving the question whether you're the employer or employee decides whether the employee's health insurance covers contraception. The Supreme Court said that corporations have the rights to exercise religion and exercise it in a manner that you know, would allow them to not comply with the normal laws for providing comprehensive health care preventive health care under the Affordable Care Act, including the full range of contraception. This past year, the court heard another case involving the same issue where the extremity of the employer's position was even stronger, even more harmful. And the court sided with the employer in that case. And the case was remanded for some further proceedings. But this continues to be a very live issue. And you know, people who are at universities, who are often among those, and you know, who really want to be using contraception, are at risk of unintended pregnancy. Your university could be deciding whether you have insurance coverage for that if the law goes the wrong way here. And your pharmacist and you know, could be exercising this sort of control over whether you're able to fill a prescription if you know, federal regulations passed during this past administration you know, were to be upheld by the courts.
Yeah, and all of that, yes. And I'll also just add that both here in the US and worldwide, high levels of unmet contraceptive needs directly correlate to high abortion rates. So it really, to me, defies logic that the same folks who aim to limit safety net programs and access to abortion would also support measures that make contraception unaffordable or like totally inaccessible for so many people. Yeah, I mean, regular use of reliable and highly effective contraception made unintended pregnancy rates hit a 30-year low in 2011, and teenage pregnancy rates are at record lows. So, you know, we know that birth control enables proper family planning, and it helps pregnant people to avoid the risk of premature birth or low birth rate. And it can help people manage all types of other medical conditions like premenstrual syndrome or excessive menstrual bleeding. And with access to birth control, you know, this is also an economic justice issue. It enables folks to achieve their employment and their educational objectives and to support their families. So, I mean, I think for every dollar that that is invested in public funding of family planning saves American tax dollars, American taxpayers like over $3 in pregnancy-related costs. So it makes sense economically, it makes sense morally to be offering folks contraception and to do so for free, like the ACA does. So I think that, you know, trying to, you know, restore this contraceptive benefit in the ACA is really going to be an important fight.
And that really ties it all together because, you know, this is juice for a secular democracy. As you pointed out, it completely defies logic that, you know, the same people who are against access to birth control also say they don't want folks to have abortions. We know that a huge part of that is driven by privileging a very specific interpretation of a specific religion over all other religions and non-religion. And that's why reproductive rights is very much a separation of church and state and religious freedom issue for all of us. So thank you all so much for joining us. Thank you to our speakers for educating us and giving us ways to take action right now. Don't leave yet if you haven't taken action. There are links in the chat that you can click right now to send letters to your members of Congress. Before we go, do you, Scott and Shannon, do you want to just share how we can follow your work personally or follow your organizations?
I have placed in the chat a press release, you know, that was requested by the Center for Reproductive Rights concerning Justice Barrett, and that press release includes a link to a longer report by the Center on Justice Barrett. The first part of that web link, www.reproductiverights.org, you can find everything important that we're doing.
Yeah.
Shannon?
At www.ncjw.org, you can find, you know, similar things to take action, press releases, and also the new Courts Matter website where you can take action on judicial nominees, which is literally courtsmatter.org.
Thank you both so much for your time and for all of your work. We know you're fighting an uphill battle, and we're glad to have you both on our team.
Thank you.
Thank you. Have a great night.
Thank you.